Yes, good morning, friends. Today we take up a very interesting topic for all of us. The topic name is Digital Personal Data Protection Act, right? Digital Personal Data Protection Act 2023. And recently this has been passed in this month only, right? So, in fact, there is so much criticism, so much confusion about this act, right? And some people said that this act is compromising right to information, right to information act, RTA act. So let us understand how it is compromising right to information act, and whether it is protecting our privacy or not, right to privacy, whether it is protecting or not, and what are its salient features, and what is its implications on big technology companies like Twitter, Instagram, Telegram, and so on. What is its implications on startups, and what is the way forward, particularly with respect to globally best practices, right? So let us begin the class without delay, and do subscribe and share the video if the video is informative, so that I can bring more and more such type of videos, right? So let us begin the class. So, Digital Personal Data Protection Act 2023. So please understand, we need to understand the right to privacy, right to privacy. So let us go back to the historical background of this act, right? So how this was arrived. If you look at the historical background, sir, Supreme Court in 2017 gave a landmark judgment, gave a historic judgment, that is Puttaswamy case, in which the Supreme Court said that right to privacy is a fundamental right. Right to privacy is a fundamental right under Article 21. So, and accordingly directed the Union government to frame laws so that the right to privacy is protected. And in the same year, Justice B.N. Sri Krishna Committee was formed. For a report on data protection, right? Because we are all living in a globalized world. So, this committee verifies the whole world, America, Europe, or Australia, what kind of practices they follow to protect the data, right? What kind of safeguards they have. So this B.N. Sri Krishna Committee was formed, and the report was also submitted in 2018, right? And after that, in 2021, a bill was placed, in 2022 also. Later on, it was withdrawn, and finally in 2023 we have this act, Digital Personal Data Protection Act, right? And the last point, sir, before this act also we have the protections, we have the data protection. The act is Information Technology Act 2000, right? The act is Information Technology Act 2000, in which there is a particular section called as Section 43. We will see in the later slides. Section 43, it says if your data is compromised, or breached by a company, then you can file a complaint. And it is the responsibility of the company to compensate users. If a breach happened, it is the responsibility of the Twitter or Google to pay compensation to the users, right? Such compensation is there in the Information Technology Act 2000, but exclusively there is no such Data Protection Act for India. You got this right? Exclusively, there is no such Data Protection Act. Data protection inherently, it's a part of IT Act 2000. But now onwards, sir, we are going to have an exclusive Data Protection Act, because we're all living in digital age, right? Digital world in which data is the new oil. You know this, right? Data is the new oil. Data plays a crucial role, particularly in the face of emerging technologies like artificial intelligence, GPT. Data's importance, no need to mention. So all the governments needs to take the action to protect the data, to whether they are using the data beneficial purpose or harmful purpose, right? This is a historical background. So let us take up the salient features of this act. Sir, data fiduciary and data principles. Just understand these terms. What is the meaning of data fiduciaries? Meaning of data principles. Please listen. We all know we have companies, big technology companies like Twitter, Instagram, Telegram. These are all big technology companies, and they collect our data, right? They collect our data, our personal data, and then they process the data, right? They may process the data and then transfer to third parties also, like Uber, Ola, and for advertising purposes, for delivering goods and services, sir, they need data. They need data not only for private entities, even government also needs data. The point is here, the simple point is, data fiduciaries means companies. Right? This is clear, right? Data fiduciaries means companies, technology companies. Then their job is to collect the data from users, right? So what is data principals? The next question. Data principals means they are individual users, that is us. What the point? We are the data principals from whom data is collected by the companies. You got this right? It means data fiduciaries are collecting data from data principals. So data principals simply means it is individual users, right? We are all data principals, right? These are some technical terms you need to keep in mind. So let us understand the rights and duties of users, individual users or a DP, right? What are the rights of users? That is we. So please listen. Every individual user has a right to delete or modify the personal data. You got this point? Suppose I have uploaded a particular photo or a video. I don't want it, so I can erase it, I can modify it, and I will talk to the company through consent manager. There is a term called, this is the first time a concept was introduced in this act, that is a consent manager. We will see in the next slide. Consent managers are appointed by companies to represent the interests of individual users, right? So individual users can talk to consent managers, thereby delete the personal data. It means, please listen sir, it means right to be forgotten is implied in this act. Right to be forgotten. You got this right? Suppose you don't want a particular data in the public domain, then you can delete it. That's why the Information Minister of Information and Technology Minister Ashwini Vaishnav, he said that in the parliament, right to be forgotten is implied in this act. Though it is not mentioned explicitly, it is implied in the act. Similarly, individual users, if they have a complaint against a particular company, they make a complaint. If they feel a data breach happened, the data violation happened, then they make a complaint. That is right to grievance redressal. A particular grievance redressal mechanism is created, and individual users or DPs have a right to access it. That is right to grievance redressal. And the last point, sir, already I have mentioned, these data fiduciaries, these DFs, once they collect the data and process the data, they transfer the data to third parties, right? This is what happening. Third parties means it can be Uber, Ola, or Redbus. They need data, right? They need data for advertising purposes, for marketing purposes. Now the question is, if they transfer the data of individual users, the individual user has a right to know. They have a right to know about the third parties, to which the information is shared by these companies or data fiduciaries. You got this point, right? If information is shared from companies, third parties, then the individual user has a right to know the name of third parties. What is the name of third parties to which my data is shared? I will ask the companies. It is my right. But please remember, sir, there is one limitation is there. I will talk later on the next slides. If this third party is a government agency, right? If the third party is government agency, then the name is not revealed. Got the point? This right is compromised. If the third party is a government agency, we will see it. We will see it in the exemptions slide. Separate slide is there. So now we will see these are all the rights of individual users or DPs. Now the duties. What are the duties of individual users? So the next is duty. So please listen. If a false complaint is made by individual user, a frivolous complaint is made by individual user because of the opinion or belief that my data was theft, and finally the conclusion is there was no such thing happened, the complaint is a false. You know the consequence? The consequence is penalty. Penalty of how much amount? 10,000 rupees penalty. You got the point, right? So 10,000 rupees penalty is imposed on the individual user if a frivolous complaint is made, right? So in fact, this is the first time. In fact, B&C Krishna Committee also did not mention this type of penalty. This type of penalty, what is its consequence? Most of the individual users do not come forward. It acts as a deterrent. For making complaints. You got the point, right? They don't raise their voice at all because of this particular fine of 10,000 rupees on the individual users if you make a false complaint, right? That's why some scholars are saying it's a bad thing. They have done some. In fact, B&C Krishna Committee also clearly said there should not be penalty on individual users, right? Let us talk about obligations. Obligations are responsibilities of DF. DF means data fiduciaries or companies, right? So what are the responsibilities of big technology companies like Twitter, Instagram, Telegram, right? So the first responsibility, sir, for the first time, already I have mentioned consent managers are appointed. You know, consent managers, the job of consent managers is to find out the interests of individual users. You got this right? Suppose I am the data principal, I am the individual user. If my data is collected, then the company needs to take consent from me. Consent means acceptance. You got the point, right? Informed consent. They need to take the consent from my side. That is why consent managers are appointed, and they are registered also. They are registered also in a particular board. Data protection board is created in this act only. All the consent managers are registered in this data protection board, and the job of consent managers is to represent the interests of DP, data principals, right? Particular complaint they need to make, then they can go and access to consent managers. You got this right? They are like a consent manager. They are the intermediaries between individual users and companies. These consent managers' job is to protect the interests of individual users or DP, data principals, right? So the next, sir, again, this is the first time. These companies, please listen, these companies are broadly classified into two types. One is small companies, other is large companies. You got it right? Small companies means startups. Just now startups, they have also some data, some little data is there, but there are some big technology companies, Twitter, Instagram, Telegram, they have some big data, right? Now the point is, these data fiduciaries are significant data fiduciaries. Why they are significant? Because they have so much data in their hands, right? They have so much data in their hands, so there are additional responsibilities. Got this right? There are some additional responsibilities to these significant data fiduciaries. Do you know the additional responsibilities? They need to appoint data protection officer, similarly data auditing, data protection assessments, right? It means they have some additional responsibilities to comply with. That is why some companies are saying, because of all these provisions like protection officer, auditing, it is expensive for them. The cost is going to be increased because of all these complications like officers, protection assessments, periodical auditing, right? Definitely the cost is going to be increased for these big technology companies or significant data fiduciaries, right? It's a grievance, but the government is clearly saying these things, these provisions are only for big technology companies. Startups need not mention these, need not to worry about these requirements, right? So the next thing is data protection board, right? So far we have, please listen, so far we have read or understood what are the rights and duties of data principals or individual users, and then we have seen what are the obligations or responsibilities of data fiduciaries or companies. So please listen, next is a data protection board is created under this act. A data protection board is created, and the thing is, it imposes fine on companies, right? Already we have talked about penalty on individual users, penalty of 10,000 rupees on individual users if they make a false complaint. Now if the companies, this is about data fiduciaries or companies, if these data fiduciaries fail to protect users data, if they do not comply with the provisions of this act like consent managers, protection officers, then this data protection board imposes a fine of, minimum fine is 50 crores, maximum fine is 250 crores. Remember this number, 250 crores. Earlier it was 500 crores. But now the recent act, this bill, the bill said that it should be 500 crores, but the act says only 250 crores is enough. 250 crores, 50 crore to 250 crores. But please listen, sir, there is a criticism. In fact, many scholars are saying this watchdog, this is watchdog, right? Data protection board is to protect data, right? Protect the data of individual users, but this is weak body. The body is weak. The watchdog has no teeth. That's what the people are saying, because all the members are appointed by union government. Got this point, right? All the members are appointed by union government for 2 years, and they're eligible for reappointment. It means the members may not act independently. Got this right? These members may not act independently. In fact, they are also clearly saying there is some European countries. In European countries, there is a particular act or regulation that is called as a General Data Protection Regulation, GDPR, which is a standard mark globally. According to this GDPR, General Data Protection Regulation, GDPR also created a watchdog just as a data protection board, but it has very strong. The body is very strong, and they take action against to all bodies. It can be private entities or government bodies. I repeat, sir, particular watchdog in this GDPR, General Data Protection Regulation, it can take action against private entities as well as government agencies also. It can be any agencies, government agencies like CBI, ED of European countries, right? But in India, that is not the case. This Data Protection Board can take action only against private entities. It cannot take action against to any government agency. Remember this. This Data Protection Board cannot take action against any government agency. We will see the next slide. We will see the next slide. So that is why the Data Protection Board, most of the people is saying it is a weak body. It is a weak body. It has no powers. It has no powers, right? It every time it depends on the government only for its survival, right? In fact, the act is also saying, the Digital Personal Data Protection Act is also saying the composition, the qualification of its members is also not mentioned in the act. You see it, right? The qualification is not mentioned. It means the union government in its discretion can appoint any person as its member, right? Anyway, we need to see the official gazette notification. It is yet to come, right? And the next point, sir, exemptions. Please listen. Who are all exempted from this act? It means what? Action is not taken on these people, right? For example, these personal data, individuals' personal data can be processed by any government agency. Suppose, please listen, sir. Suppose a disaster happened, a flood happened, an earthquake happened. At that time, consent is not required from the individual users, right? That's obvious, right? If an earthquake happened, it is not possible to take consent from individual users. So at the time of medical emergency, disaster, or for research purposes, consent is not required. You got this right? Personal data can be processed by government agencies in the interest of sovereignty and integrity of India. You got it? Means all the government agencies are exempted from this act. It means the Data Protection Board cannot take action against to almost all government agencies. You got this right? In fact, some areas are mentioned by the government in this act, almost some broad areas. You know, the exemption is so broad that in fact, all government agencies are out of purview of this act. That is why the people, some people in the Congress, people have said in the Parliament, this act is only applicable to private entities. It is not at all taking action against government agencies. All government agencies are exempted from this act, leading to surveillance state. Got the point, right? State is watching you. State is supervising or monitoring your every action. And the government agencies are excluded from penalty of this act. No penalty is imposed. No action is taken against to any agency which is a government, right? Earlier I have told you, in a particular slide I have told you, individual users, right? Let me open the slide. This point, the C point, right, in the duties of DP. Data fiduciaries can share the data to third party, right? If the third party is, please listen, if the third party is a government agency, then we cannot have an access to know about which government agency has taken our data. You got the point, right? It means what? If the third party is a government agency and the data is used for some legitimate purposes, then our right is compromised. Then we are kept in dark. You got the point? We are kept in dark. Even without consent also, our personal data is compromised by government agencies, right? That is the point. So where is the right to privacy? Got the point? Right to privacy is compromised if the particular third party is a government agency. How fair is it fair? Got the point, right? We cannot say that government is not a divine. Government is not divine. Government powers are limited. There should be some checks and balances on the powers exercised by government. But here in this act, there are no such safeguards against government agencies if they do some misuse. You got the point, right? The CBI or ED or Intelligence Bureau, if they misuse the personal data of us, then there is no safeguards. There are no checks and balances. We cannot take any action against them. You got the point, right? We cannot take any action against them. You will come to know. You may say, sir, I will go to High Court because Puttaswamy case is there. No, you will not go to High Court after this act. You will come to know. They made such provisions. You will not go to High Court. They made such provisions. You will see Data Protection Board exemptions. The exemptions are very clear. A blanket exemptions are given to government agencies. It is clear, right? A blanket exemption means if the agency is a government, then no action is taken against them, right? It means you're completely transparent. Individual users are completely transparent to government, but the government is not transparent, right? That's what the criticism, in fact. Anyway, don't take. Let's take the amendments, sir. this particular act, amended two acts. The first act is IT Act 2000. Please see, first act is IT Act 2000. Earlier I have explained you in this video only. Section 43A. In this section 43A, it clearly says companies, it can be any company like Twitter or Instagram, if your data is breached, right? If the data is breached, then it is the responsibility of the company to pay compensation for the individual users, right? Compensation should be paid by the company to the users if the data breach is found. That is what the section. So it clearly says companies are obligated to compensate users, right? If the data is mishandled or breached. But now you know what happened now in this act? In this act is clearly saying section 43A is not applicable to this act. You got the point, right? It means what? Do you know what does it mean? You cannot go to High Court. Compensation is not available, sir. If compensation is available, you can go to the High Court for compensation. A judicial action can be taken if compensation is there. But now the Digital Personal Data Protection Act is clearly saying section 43 is no more applicable. Section 43 is no more applicable means no more compensation. The government will decide. It is at the discretion of the government whether to provide money or not. You got the point, right? And the government is saying, if it is compensation by the judiciary side means it takes time. Anyway, just look at the argument of government. The argument is, if the compensation by the judiciary side means it takes time, we will take expedite action. You got the point, right? We will take expedite action. That is why we have removed section 43 application to this act. You got the point, right? The simple point is, from now onwards, there is no compensation for the individual user. There is no compensation for the individual user if the data is breached by the company. Because section 43A of IT Act is no more applicable to this act, right? It means that's why the individual user has to go to only grievance officer or data protection board only. You got the point, right? That's why they twisted. You need to go to data protection board or grievance officer, right? And the most important thing is right to information. Listen to the point. Right to information, and it is a revolutionary act because of the reason that it ensures transparency and accountability in the functioning of government. We all know this. That is the background of IT Act, right? For social auditing mechanisms, for public scrutiny, we know the importance or significance of Right to Information Act, right to information, right? And the right to information is also a fundamental right. But you know what happened because of this act? Listen, there's a particular section called as Section 81J. Section 8 is, please listen, Section 8 is all about exemptions from information, right? All information is not disclosed. There should be some exemptions, right? The one exemption is Section 81J. Listen, what is Section 81J? You need to understand, right? See, there is some information. If that information is disclosed, it may lead to infringement of privacy. You got the point. It may lead to infringement of privacy if that particular information is disclosed. That is why Section 81J says it exempts the information. Please look at the slide. It exempts the information that causes unwarranted invasion of privacy. You got the point. If particular information is unnecessarily hurting the privacy of an individual, unwarranted invasion, it's not needed, then that particular information is not given to the people, right? That is all about Section 81J. But please listen, but the public authorities, the public information officer, they may disclose, they may open the information if that particular information, by opening that information, a larger public interest is served. You got the point, right? It means what? That particular information is also kept in the public domain if a larger public interest is served. You got the point, right? There is no such privacy. Anyway, there is also another standmark also, another benchmark also. Please listen. Another benchmark is, please listen, any information which is accessible to Parliament and Assembly. Any information which is accessible to Parliament and Assembly, it cannot be denied to citizen. Let me put this simple way. Suppose an individual user asks a particular information. The information is, please listen, the information is, I want to know the assets of a civil servant, IAS officer, right? Particular IAS officer is there. He has so much property, so much assets is there, so much gold is there. I failed RTA to know about the how much assets are there with this IAS officer, right? No, he says that it is my privacy. You got the point, right? It is my privacy. It should not be revealed at all. But the public information officer, you know what does he do? He reveals the information. The reason is IAS officer is a public servant. By revealing by revealing, by disclosing how much assets he has earned, it serves larger public interest, right? That is the purpose of section 81J, and that information is also open to parliament or other legislative authorities. You got the point, right? If a particular information is accessible to parliament and legislative bodies, that particular information should also be accessible to citizens. It should not be closed. You got the point, right? The PIO, the public information officer, should not say that on privacy grounds this information should not be given, right? So the final point, sir, if any information is there, if it is serving the larger public interest, it can be disclosed even though privacy is compromised to an extent, right? That is what the object of section 81J. You know what happened? Now listen, what is amendment? You know what is the amendment now? Now section 81J of IT is completely amended. You know how it amended? The amendment is, if any information related to personal information, it is barred now. You got the point, right? If I ask about the assets of an IAS officer, any government servant, now it is barred. Now it is no longer in the public interest. The public authorities, the public information officer has no discretion now. You got the point, right? Earlier, the public authorities or PIO, you know PIO or public authorities, they have some discretion to disclose the information of personal information if it serves larger public interest. Now the door is closed. Now the door is closed. It is amended the act. It shielded the personal information of citizens. Now the section 81J is amended in a manner that personal information of all the citizens is completely shielded. You got the point, right? It means the RTA Act is compromised. That's why the people are saying, why have you compromised the right to information, right? Anyway, the government needs to answer. And the last point, sir, exemptions. We have covered the exemptions, amendments also. Two amendments. One is RTA Act 2005 and IT Act 2000 amended. Way forward. Please listen. I have already said that data is the new oil. Data is most crucial for emerging technologies like artificial intelligence. You heard about ChatGPT, right? So personal data protection is needed, right? Data protection is needed. At the same time, processing needs to be done, right? Processing, why do we need processing? To deliver goods and services to citizens for good governance, for effective delivery of goods and services, data processing is needed, right? For advertising purposes, for marketing support, right? Data processing is needed, but the thing is striking the right balance between data protection and data mining or processing, right? And that's why we need to look at the whole world, globally best practices, what kind of best practices are followed by European countries or other countries, so that we keep safeguards, we keep proper checks and balances against all entities, not only private entities, even some government agencies also need checks and balances. I got it right, because government is not divine. Humans make mistakes. Government also does make mistakes. You got the point, right? That is why, anyway, don't criticize the government, right? Because you may be aspiring to become a government servant, right? If you want to join a government job, means you should not criticize the government. Just put it. There are some positive features also there, right? We need to improve further in line with the globally best practices, right? Do not take a negative stand, right? Criticism needs to be presented in a constructive manner. Do remember this point, right? So the question is, discuss the salient features of this act and how far it is effective to protect our data. How far it is effective to protect our data in the light of global practices. There are global practices I have mentioned, GDPR, General Data Protection Regulations of European countries, how effective they are safeguarding, and what are the problems, what are the lacunae present in this particular act. You can mention, but finally in the conclusion you need to take a positive stand. What is the positive stand? We have some obligations also we have given to the companies, but the only thing is government entities are exempted, right? Anyway, the government may change their stand in future if they see that government agencies also need some checks and balances, some safeguards, right? So let us end here, and do subscribe and share if you need more such videos, right? And do make some comments if you want to know more about this act, right? Let us wind it up. And do have some questions, sir, in the comments section. I'm happy to answer, right? Thank you.